tuned in to The Andrew Lawton Show.
Let's take a look at the bigger picture. I always like doing that from time to time, especially in this country. And when it comes to legal matters anyway, there are few people, in fact, I'd say probably no one better to do it with than Bruce Pardy, who is the executive director of Rights Probe and also a professor that is probably worth anyone in law going to Queen's just so they have a chance at getting Bruce Pardy as a prof. Bruce, good to talk to you. Thanks for coming on today.
Great to see you, Andrew. Thank you. That's really kind of you.
You had this great piece in C2C Journal, Canada's Constitutional Mistake, how the rule of law gave way to the managerial state. And normally with these sorts of things, I do like a bit of a wind-up before I bring the guest on, but I actually thought it would be more prudent here to let you describe what is your thesis here? What is it you're saying?
Okay, here's the core of the idea. We've gone through centuries of legal and political reform starting in England. To go back to the original problem. The original problem was these kings who ruled for centuries, and some of the kings were bad and some of the kings were better, but essentially the kings had absolute power. Whatever they said was the law. And then slowly, starting perhaps with the Magna Carta in 1215, we started this long process of taking power away from the king and giving it to legislatures. And eventually we got to the stage in the British system of arriving at this idea called legislative supremacy, meaning the legislature is supreme, not the king. The legislature can enact any laws that it wants, because after all, it has democratic legitimacy. But the problem was this, that legislatures turned out that they could be tyrannical as well as kings. And then the Americans came along. And the newly independent Americans said, okay, we're going to fix this problem as well. We're going to enact a Bill of Rights. And they put that in their constitution. And then 200 years later, we did the same thing in Canada with the Charter of Rights. So what they did was take power away from legislatures and give it to courts. Problem is that the courts now kind of abuse their power by doing policy and making decisions that are not based upon the text and the living tree and all these kinds of things. You'll hear people complain about this all the time. So here's the problem. All we've done from the very beginning is move power around from place to place to place to place, from king to legislature to courts, and now from courts and legislatures back to, if you like, the king in the form of the administrative state. And so we proceed with this idea that the final word has to rest somewhere, but nowhere seems to work. And that's the mistake. The mistake is, instead of moving power around, we should have taken power away so that the power rests with us individually.
It's a fascinating thesis, and I'm glad I had you explain it, because you did it so eloquently there. And what strikes me when you describe that there and also in your essay in C2C Journal is that at every stage, we've been told that the shift is to give power to the people. When power is taken from the king and given to legislatures, going back to Runnymede and Magna Carta, it's because, the legislators are the representatives of the people. When it's taken away and you have a constitution, I mean, the sales pitch from the founding fathers of the United States, and I believe them to, with my knowledge of history, be authentic in this desire, was that we need to put a constraint on the state's power. But you cannot do that without an intermediary, without an adjudicator, and that's where we go to the courts. Now, I'd say in the United States, the courts have done a better job at keeping to the intent of the Constitution, but in Canada, we have the opposite. I mean, the quote that I bring up from our former Chief Justice from time to time, Beverly McLaughlin, is where she described in her memoir her job as being to take a step back and hear the facts of the case and then decide what's best for society, which is actually more dangerous than just letting the legislature have free reign, I think, is to have someone for whom there is no accountability trying to really, by very definition, socially engineer. So we have this libertarian utopia that we seek of wanting individuals to be sovereign. How is that possible?
Right. So if you start with the opposite premise, so the premise that we have now essentially is that the state and the state comprised of these various institutions, legislatures, courts, and administration, that the state has the authority to govern. And these various branches of the state are supposed to act as checks and balances on each other, but they're all basically on the same page now, so they don't really act as checks and balances very effectively anymore. So the opposite premise would be, instead of authority of those who govern, it would be the consent of those who are governed. And by that I mean not the will of the majority. I don't mean consent as a group. I don't mean by vote or referendum. I mean every person gets to give their individual consent to be subject to laws. Now, if we're going to premise the system on consent, you start with that idea, which means, by definition, if you like, that no one, whether you're a fellow citizen or the state, can impose force against you. They can't coerce you. And that becomes the first rule of the legal system. No force, no coercion, no threat of force. And then from that, we get all kinds of rules about theft and battery and assault and all those, lots of things that we already know and love in our legal system. But then once you get beyond that rule, then for all the other rules that have nothing to do with force, each of those laws requires the individual consent of each individual citizen, without which those citizens are not subject to those laws. Now, that's a radically different system. And people will obviously have lots of questions, and understandably so. And those questions can be worked out. But let's not throw away the idea just because it's strange, because it needs to be strange, because the system we have right now isn't working very well.
I think there might be some minor steps that have been, I don't want to say missed, but really sub-steps that have taken place in this trajectory that you explain. And one of them that I studied in school, and I should probably have Ted Morton on the show to talk about it, is the establishment of what, I mean, you're well aware of it, he called the court party, which was basically courts becoming overly deferential to social justice groups and activists. And this was like the 1990s that he wrote this. And I think the problem has gotten much worse since then. So you even have within that this subcategory of disproportionate weight being given to special interest groups, which has, I guess, fallen under the banner of the judiciary. And I wonder if the next stage of this, where we're heading, is not necessarily rule by the mob, but rule to this even more obscure and malleable group that is really embedded in the courts, embedded into the political class, embedded into the bureaucracy, which, I mean, at its core is really DEI.
Sure. Yes. Well, we would say we have a huge managerial state problem, the way I would put it. And the bureaucracy and, well, frankly, all three of them, the bureaucracy, the courts, and the legislatures are working together, essentially. I don't mean that they don't have their disputes and quarrels. They do. And I'm not saying that the courts never overturn decisions of the legislature and or the bureaucracy. That's not true either. But in a general sense, in a broad sense, they all fundamentally believe in the need to manage society. And they all work towards that end. And so you're not going to have a genuine check and balance from any of these outfits. So you can see the way people react to bad decisions. When a court makes one of these creative decisions based upon the living tree or an interpretation of the words that the words don't really seem to reflect, then they'll complain about the courts having power, and fair enough. But then, when legislatures say that they're going to invoke the notwithstanding clause, they react kind of the same way, which is, well, the legislature is abusing my charter rights, and I want the court to have the final say. But you just finished saying that the court wasn't doing a very good job. And then when we have a bureaucracy making the final call, like during COVID, you'll wear a mask here and take a vaccine there and so on. People complain that the bureaucracy is making the calls and not the legislature. Okay, well, come on, people, make up your mind. The problem is there is no good answer to this. They're
No, but
all
also it's where they want the outcome and they don't really care how they get to the outcome. So there's no desire to be consistent on when they want legislative supremacy and when they want judicial supremacy. It's whatever gets them where they want to go.
see you are getting now to the nub of the difference between what the law actually is and what it actually does compared to what it's thought to do. So one could go so far as to say this: the role of the law in society maybe is not reasoning to a result. It's justifying a result that they want to reach. And those two things are quite different. And where we may be giving the law too much credit for being, objective and solid and immovable and immune to the currents of cultural change. It's an institution. It's none of those things. It's liable to be influenced by culture in the same way that any other of our political institutions are. And so we have to acknowledge the reality of the way the thing works.
I think there are, and you and I have spoken about this in the past, some structural issues in how Canada's charter was created. This idea of having the Section 1, which really nullifies much of the rest of the charter. The notwithstanding clause itself is problematic. And I say that to contrast it with the United States, which has had I think their Bill of Rights is a much stronger and more rigid document. But even so, the problems between the two are, I think, the same in that, I used to look at the US Constitution in a much more favorable light than I do now, not because the document itself is flawed, but as my friend Mark Stein says, waving it around in the air doesn't really get you all that much. And that's when we go to the point that all of these things are not worth the paper they're printed on, literally, if you don't have institutions that are upholding them. And we've seen that the institutions are not as rooted in what they need to be. And I guess the question that I fear asking about is, can that come back?
Well, the point that you made about the U.S. Constitution is quite right, I think, in many respects. I mean, I think it has fared better as of right now than the Canadian Charter has, but it's not been a straight line. I mean, like the Canadian Charter, the American Bill of Rights has been subject to judicial interpretation, which has waxed and waned over time. And some of the decisions under the U.S. Bill of Rights have not been decisions that you and I would like over time. So, yes, your point is quite right, that it depends upon the institutions who are applying it, which makes the point that the document itself does not govern. It's the people who are making the decisions who govern. And that, it's a funny thing because people instinctively understand that. They make jokes about it. It depends upon the judge, I get. But there's actually more truth to that than they think. And you can't... language has inherent ambiguities. And so the idea that we're going to fix the charter or fix the Bill of Rights by simply drafting it better, more precisely. Now, don't get me wrong. There are some really vague provisions in the charter that could have been done much better. But nevertheless, it's unlikely that you can ever draft a document that compels every single answer for every case under the sun. It just doesn't work that way. So you're going to have to acknowledge the fact of the ambiguity and acknowledge the idea that the way the system runs is in fact going to depend upon the ideas in the heads of the people who run the institutions.
So we have then two problems, one of which is, can the law be, well, I guess they're all really coming under this one question, which is, can the law be safeguarded against people? And it's ironic that the law, which at its core, we want to be there to protect people, is, still being weaponized by another group of people, whether you want to call them the elites, the state, the institutions, the courts, whatever the case is. And it's a very strange dilemma because at its core, we're back to the original problem we have in a way, which is that there is the need to save people from other people. And there isn't really the answer to how to do that.
Well, so it's funny you should put it that way, because if you like, you can contrast the two competing ideas this way. You can say, look, if we stuck to the idea that the role of the law and the courts and so on was to save people from other people, from the interference of other people, if we all agreed about that, then we might not have such a big problem. But we don't agree about that. The other competing purpose that a lot of people think that the law should serve is to protect people from themselves. to put rules in place to prevent people
Mhm.
from making their own decisions about their own lives because other smarter people think, oh, well, that's not a very good idea. You know, for my money, that's a terrible thing. But a lot of people thoroughly believe that. I've said that those people who think they believe in liberty need to come to two epiphanies, not one, but two. And the first one is easy, and the second one is not. The first one is, well, I don't want to be told what to do. Well, that's easy. Anybody can come to that conclusion. But the second one is, I don't want to tell other people what to do, even though I think
Much
I'm
more
smarter than them.
challenging.
Yeah. Until you get there, and until you get the people inside the system running our governments to believe that as well, then you're going to have a problem.
And that is where the one little bit of hope that I try to find in all of this is that there's always the hearts and minds approach, is that, none of the what's on paper, what's in the institutions doesn't matter if people are behaving the way we need people to. And that is embracing freedom, embracing free speech, embracing the ability to self-govern in this sense. So it was a very, very thoughtful piece. It's in C2C Journal. You can read it for yourself, and I would encourage you to do so. Canada's constitutional mistake, how the rule of law gave way to the managerial state. Bruce Pardy, always a delight. Thanks for coming on today.
Great to see you, Andrew. Thank you.
Thanks for listening to The Andrew Lawton Show. Support the program by donating to True North at www.tnc.news.